Good afternoon to everyone. This is Scott Adams. I'm a real estate partner here at McGuireWoods based in our Northern Virginia office. And I wanted to welcome everyone to what we think is a very timely webinar today on real estate tax appeals, which has really become a ever more frequent topic of conversation with our clients under the current circumstances. So before we jump in with our panelists, I wanted to give everyone some quick highlights and information on our firm and on some of the current events, in light of the current events, some information on our COVID-19 task force. So McGuireWoods is a national full-service law firm with 21 offices and 1,100 lawyers around the world. Our real estate and land use team within the firm consists of approximately 90 team members that span a wide range, and our practice spans a wide range of traditional and non-traditional real estate transactions, litigation, and generally all aspects of the real estate practice. On the litigation side of the house, we have upwards of 100 lawyers who practice complex commercial litigation, advising clients regionally, nationally, and globally. And as you'll hear from our team today, our litigation lawyers have extensive experience advising clients on all aspects of real estate litigation, including real estate tax appeals. McGuireWoods has been at the forefront on the COVID-19 front, providing business, legal, public affairs, and crisis management expertise to our clients as they're trying to navigate a lot of the challenges that are arising from the current crisis. And the firm has put together a broad-based COVID-19 task force to advise our clients on the broad range of issues that are arising in the current climate. So I encourage everyone to check out our website, which has a lot of really great information on COVID-19 and advice in responding to the same. So with that, I will turn it over to my colleague, Greg Riegel, to introduce our panelists and kick off the substantive part of the program.
Thank you, Scott, and welcome everyone. It's good to at least indirectly see so many friends and clients joining us today. And as Scott said, I am Greg Riegel and privileged to be a partner in the real estate department of McGuireWoods. I also serve as the managing partner of our Tysons, Virginia office. Before we get to the panel, a couple of very quick practical things. If you've never been to one of our webinars, there is a question and answer sort of function. You can type questions electronically. What we're asking is go ahead and do that, and the panel will do the best we can to respond at the end of the overall presentation. And if there are questions that require follow-up offline, we have a mechanism to do that, and we have contact information on everyone that is joining us today. Similarly, contact information for all the panelists is available or are available to the extent you have further follow-on questions after the topic is concluded. And as Scott said very correctly, we're doing this today just because of rising client interest in the collective subject. And it goes without saying that the current events surrounding COVID and the coronavirus are undoubtedly going to have impacts on real estate values going forward. We're also in a situation with some deadlines approaching from prior year tax assessments that we need to be mindful of. So we're going to try to have hopefully a good overview discussion of the process for tax appeals, the legal standards. This will not be a granular discussion on specific property circumstances. Those are obviously fact-based discussions and decisions, but hopefully you'll come away all the better with some perspective on at least how this works and how you can avail yourself to the appropriate processes. So with that, by way of introduction, I am very pleased to introduce my colleagues, John Wilburn and Brooks Spears. Both are active members of our Tysons litigation team and effectively anchor this practice area for the law firm. And we are equally privileged to be joined by Bill Harvey. For those of you who travel in real property circles, if there's such a thing in Northern Virginia, Bill does not need an introduction. He's a very skilled appraiser. He serves as an expert witness on trials and litigation on a frequent basis, and is a former member of the Fairfax County Board of Equalization, and also an all-around very good guy. So I'm going to pass the proverbial or metaphorical baton to my partner, John Wilburn, who will take you through the presentation with the other panelists. And again, thank you for joining us.
Thank you, Greg. My name is John Wilburn. I'm an attorney here with McGuireWoods, and thank you for joining us today. As everybody is probably painfully aware, the world today is remarkably different than it was when most of us received our notice of real estate tax assessment in January or February. This new normal that we're operating in impacts not just the local, but the national and world economy. And there's some concern, I think some reasonable concern, that this new normal is likely to depress commercial real estate activities and values, at least temporarily as we move through this, and perhaps more permanently as our behaviors, both as shoppers and as workers and consumers of products that are available in society, as that changes. Some obvious economic evidence that suggests that perhaps we may be in for a bit of a downturn is, employment levels have gone from historically high to historically low in the time that from the beginning of the year to current. Personal, corporate, and government debt has gone up. Mortgage and loan defaults are on the rise. Mortgage workouts are on the rise. It's not all bad news, but we're dealing with these circumstances that are rendering market conditions at a minimum unclear, if not worse. At the same time, COVID has required that we change the way we work and change the way we shop, which has an impact on brick and mortar businesses and resulting impact on their valuation. As everybody knows, we're rapidly moving towards a digital economy. Digital sales are through the roof in the last couple of months, while brick and mortar businesses are largely shuttered. People are eating at home rather than going to restaurants. They're working out at home rather than going to the gyms. As I mentioned, they're shopping online. Our local malls are closed. What's been required based on these executive orders and government shutdown could become habits that could lead to a mass closure of businesses that would leave a glut of brick and mortar retail locations vacant and having a consequential impact on price and value. The examples are well known. National restaurants like Cheesecake Factory are choosing not to pay rent. National retailers like J. Crew are going bankrupt. And anchor tenants right here in Northern Virginia like Lord & Taylor and Neiman Marcus are pledging to either go bankrupt or shut down their stores in the near future. As anchor tenants like that close down, co-tenancy clauses may be implicated, putting the property owners and developers at further economic risk. The possibility of a new virtual workforce is also growing. Our office is working virtually. Probably many of your offices are working virtually, and there's at least some feeling that a percentage of employers are going to learn that they either need fewer employees or they need fewer employees housed in a brick and mortar office space. More can work virtually. That may lead to closing offices altogether or to downsizing offices to smaller offices. Large tenants like WeWork are missing rent payments. They missed their April and announced they're not making their May payment. So all of those are the circumstances that we think have a significant impact on property values. And because of the timing, these properties were largely assessed at the beginning of the year, and the appeal dates or the challenge dates for those assessments in some cases have passed, and in some cases are coming on us quickly. It's not really the fault of the assessing authorities, at least at this point, that this has happened. They assessed before these COVID impacts occurred and were known. But the reality is we don't know yet the impact on occupancy levels, rent levels, what sectors will recover and what sectors will contract. And that uncertainty in and of itself, I suspect, creates an impact on value. The other side of the equation, I've talked about sort of the landowner, developer, real estate side of this equation. The other side is the taxing authorities. As you know, taxing, at least in Virginia, is a power of the sovereign. All real property in the Commonwealth of Virginia is subject to local taxation only, so you're taxed according to what your local jurisdiction dictates, and that's a combination of the assessment and the tax rate. What we do know is that these localities are themselves feeling the pinch as well. Their budgets are impacted significantly by COVID. By way of example, we looked at the budgets of some of our area up here in Northern Virginia counties, and one of them identifies in their most recent budget iteration 8 streams of revenue that go into their general fund. Of those 8 streams of revenue, including property tax, permit fees, other taxes, charges for services, the county predicts that 7 of the 8 will decrease, in some cases significantly, over the next year because of COVID. It's going to create a budget shortfall for them. The one area that the county identifies as actually increasing in revenue is real estate taxes. So I think there's inevitably some tension between what's happening in the marketplace and on the other side of the equation, the localities and their need to meet budget in these difficult times. And I think some of that energy is going to be focused on real estate taxes. In terms of sort of mitigating the impacts of COVID, there's been a lot of talk about things that can be done, but in terms of action, what you've seen in Virginia are some extensions of time to make payments. In other jurisdictions, there's a waiver of late penalties and fees, but the concept of reassessing these properties in the ordinary course and outside of the processes that we're going to talk about today available to you to appeal your tax assessment really isn't one that's gotten much traction. We did a survey, and while it's not complete, there are only a handful of jurisdictions in the country that have identified an intent to reassess their properties because of COVID. There's Cook County, Illinois is one, and there are a couple of jurisdictions in California that are going to do that. So I suspect that a lot of that reassessment process is going to take place through the processes that we're going to describe here. Obviously, they vary by state, and they vary sometimes even by county as well. But we want to talk to you about some of those today. Tax rates, as I mentioned, it's governed by statute in Virginia, but the General Assembly has delegated in Virginia the power to make assessments to each county. So the Board of Supervisors sets the rates for their county. Fairfax County Board of Supervisors will officially adopt their 2020 rates on Tuesday at a meeting, although it's expected they will reaffirm last year's rate, which is 1.15%. The original plan was to increase the rate to $1.18 per $100, but they've decided to maintain the existing rate. Loudoun County Board of Supervisors has already set their rates. They did that in April. The base rate has come down just a bit. It's now a little over $1.03 per $100. You'll see that taxes can be, sorry, I'm a little bit of trouble with that thing here. Sorry about that. I'm struggling with the slide just a bit. The property assessments themselves, once you set the rate, you've got to assess the property. The Constitution requires that the assessment of real estate be at the fair market value, and that's by virtue of the Constitution. It's a concept that's well settled both in Virginia law and also under the Uniform Standards of Professional Appraisal Practice, which Bill can talk to in just a moment. The valuation date by statute is either January 1 or July 1 of the assessment year. It depends on the county. Each locality has an agency that performs the assessments, and the name of the agency depends on each county. Each county has their own name. Notices of assessments are typically mailed in January or February. And Bill, you're on the line. Can you talk a little bit about what fair market value means in the context of appraisal practice?
Well, it's the standard of value that's addressed in the controlling case law in regard to Virginia as to what is, in essence, is being taxed. And the estate that's also a tax is the fee simple, not to be confused with either a leased fee or leasehold. So, the definition is well established, and the practices all surround, that standard of value. The other standard that is of great concern with regard to ad valorem taxation is the standard of uniformity. So both of those have to be dealt with, and they don't always agree with one another. So there is an inherent conflict sometimes in the making of an assessment or a reassessment for those two standards, and their conflicts that can arise.
One of the kind of overarching things that you'll see with these slides is that although the General Assembly has, through the Virginia Code, set out a lot of high-level guidelines and requirements for how the real property tax assessment process works in various localities, it is largely up to the individual locality to come up with some of these things. So, for instance, deadlines, the frequency of assessments, whether the administrative appeals process is a prerequisite. So a lot of these things are just on a county by county or city by city basis, and just need to be looked at that way.
But the sort of the overarching obligation by the municipality is to assess these properties based on fair market value, and they're also to do it, as Bill mentioned, in a uniform way. You can't have a lack of uniformity. And they're also to be done in accordance with the USPAP standards, these uniform standards of professional appraisal practice.
Let me clarify that just so the audience understands that an employee of any municipality who doesn't hold a license under the Virginia Code and Virginia Administrative Code is not required to comply with all provisions of USPAP. They still have to act ethically and they have to be competent. But if they're not licensed, they can't be held to that standard. But most practitioners who will be involved in the appeal process, and many staffers in municipal tax agencies are in fact licensed. So going back to what the Attorney General said when licensing first came into effect is, once licensed, you have to comply with it. And therefore, USPAP has taken the Uniform Standards of Professional Practice, the applicable standards that deal with real property, single property valuation versus mass appraisal, which is at heart the universe of properties that ad valorem taxation addresses, has taken a much greater role of late, and that's why it has become increasingly important for attorneys, practitioners to be well aware of the controlling standards and how those standards apply in the real world.
Bill, in your experience, have you seen a great variation between compliance with USPAP among jurisdictions, meaning a jurisdiction such as Fairfax? Do you find that they have folks who are licensed and therefore track USPAP as part of their assessment process versus some of our other jurisdictions and maybe do it in a less USPAP compliant way?
Well, I think you're going to find basically three classes. And so let's take the largest municipality, Fairfax. They have, a well-educated, well-trained staff, many of whom are licensed and will be very up on the latest USPAP standards, which come out in a biannual publication. So presently we're in the edition for 2020 and 2021. On the other side of the coin, you have rural municipalities, such as Augusta County, who outsource, who contract with a third party to do their reassessments. So generally, you will have very little staff and maybe just a commissioner of the revenue who takes care of the contract. That party may have no familiarity with USPAP, but the contracting party, and hopefully the contract itself, will require conformance with the controlling standards. And in between, you will have mid-sized counties who have staff. They're burdened with doing an awful lot of work. I think the average, when I last computed, the average cost for the budget in Fairfax County per assessment was perhaps $18 for their 170,000 tax parcels. So you have of proficiency, staffing throughout Northern Virginia and Virginia itself that have to contend with these ever-changing standards.
Yeah, I think that's a great point that you made about the volume of appraisals and the cost allocated to, by the county to complete these assessments. And, for those of you on the phone, nobody should know your property better than you, and almost certainly you will know it better than the tax assessor who has thousands of properties perhaps to get assessed within a relatively limited time period. It doesn't mean they're not good or don't do a good job, but the opportunity to miss something that's property specific like a property-specific use restriction or some other impediment to development or something specific that impacts your income, the opportunity for the assessor to miss that, given the volume of work that he or she undertakes each year, is significant. And so, just as a practice point, it makes sense to look at your assessment, make sure you understand it, and if you don't understand it, try and get a copy of the assessor's file or talk to them.
Yeah, and on that point, Bill can talk more to this, but lots of times, especially in larger counties, these assessors will employ mass appraisals that oftentimes don't account for the individual characteristics of a particular property. And that can often be grounds for appealing one of the assessments under the USPAP prong. But again, Bill can talk about that as we get later on in the presentation.
If and when you decide that your assessment is something you want to appeal, there are different options available to you under Virginia law, some of which are prerequisites to the others and some are not. You really have to understand the locality in which you're in. We're talking first about administrative appeals, and this is the most informal process available to you. Any taxpayer can request an administrative review to the taxing agency. It's typically the quickest and least costly path for relief. It's informal. Some jurisdictions allow you just to pick up the phone and call. Others you can email, but the basic concept behind it is you reach out to the taxing authority, explain to them what your concern is with the assessment. You'll generally have some informal discussions with them, maybe share information, and sometimes the assessor will actually want to come out and see the property again. The process and deadlines vary by county, so you need to be mindful that if you intend to employ this process, that you understand what the deadlines are to do it. You also need to understand that if you're in a jurisdiction that requires an administrative appeal as a prerequisite to a Board of Equalization appeal, you recognize that obligation too, and it just does vary by by county.
And just in Fairfax County, that deadline was May 1st for the administrative appeal. However, the administrative appeal in Fairfax County is not a prerequisite to Board of Equalization appeal.
The administrative appeals are a good time for you to provide market data in support of your appeal. As I mentioned, the assessors are dealing sometimes with thousands of properties and may not know your particular property, likely don't know your particular property as well as you do, and you can share those particularities with him or her. The taxing agency may request a field inspection to verify certain characteristics of the appellant's property. That process is very helpful, but some jurisdictions have suspended the physical inspection portion of this due to COVID. You never want to deny a field inspection unless there's some reason that that is unique to the property and that you think would create some other problems for you legally. Denial of a field inspection is going to raise red flags with the taxing authority. It'll be viewed unfavorably to them. The end result of this process is that your assessment could be affirmed, it could be increased, which is a bad outcome, obviously. It could be decreased based on the staff's analysis. It is an informal, relatively inexpensive process. I think that those are the obvious benefits. There are some negatives that you just need to be aware of. If you go through this process, you need to understand that if you later go to the Board of Equalization or you file in the circuit court, that the information you provided, the things that you said about your property can all be used against you. And if you haven't, as some clients often don't, if you haven't retained an appraiser, you may go in without some of your best arguments or making representations about your property that are frankly wrong, and that can come back to bite you later. So we think that, obviously depending on the assessment and the value of a change in the assessment to you, it makes sense to, if you don't have counsel, then to deal with somebody like Bill Harvey or an appraiser that can at least give you a reality check on what you can expect and make sure that you're ticking the valuation boxes you need to tick to get their interest. Bill, do you have any thoughts on the administrative appeal process and its value?
Sure. I think for most taxpayers and for the associates that help them determine the appropriateness of an assessment, the first obvious question is, can I sell my property for what it's being assessed at? If the answer to that is likely yes, the grounds for any type of appeal are diminished. But if the answer is no, then it begs for why can't you sell it? And a lot of times, an assessment database pre-exists as properties are brought online. That's when the property card is first developed by staff. Most of the time, they spend a good deal of time discovering the physical characteristics of the property they're adding to the tax base. But the principle of change is ever present. Properties change. They depreciate. Improvements can be added on to or have portions demolished. And that's the instance where an administrative appeal is likely to yield inexpensive but quick relief, because if the card hasn't been updated, and not every card will be updated, a lot of them will be trended forward and not revisited, but that's what triggers the request from staff to come out and take another look at the property. At this period of time of COVID, where inspections are suspended, it's a great time to offer digital images to that staffer and say, look, here's a photo of the rear of my home, and you can see I no longer have a porch, but you're assessing my property as if it has a porch. So that's the obvious instance when the administrative appeal is in the best interest of all parties, as well as the assessment data assessors. They would like to make sure their records are as accurate as possible as well. As they track sales, they will attempt to match those sales to the physical characteristics of the properties that were sold. So the accuracy of their sales price to assessment ratios ultimately are reported en masse to the Virginia Department of Taxation and have a lot of implications. They need to be accurate, and therefore accuracy is in everybody's best interest.
So the administrative appeal is sort of the first tier of appealing a tax assessment. Next comes the Board of Equalization. The Board of Equalization is something that's created by statute. It's essentially a board impaneled to determine whether an individual assessment actually represents fair market value. And as we mentioned, in some counties, you do need to file an administrative appeal in order to then file your appeal with the Board of Equalization. The deadlines between them vary, but typically, a few months in between those deadlines for each appeal. The individual members of the Board of Equalization can be appointed by the Circuit Court or, in some counties, the Board of Supervisors. The qualifications for the board members are they've got to be residents of the particular jurisdiction where they sit on the board. At least one member by statute has to be an appraiser or a real estate professional, and then all members are required to. And this is a important part of the code, is that they're required to take some type of educational course provided by the Virginia State Department of Taxation, and that helps ensure that a baseline amount of knowledge about these oftentimes complicated issues regarding real estate appraisal. And then for the actual appeals process, any taxpayer is allowed to utilize this process, assuming again that the deadlines are met. You can do it for the current tax assessment. So if you've missed the deadline for the prior tax assessment, you can't go back and redo that one. You got to do it for the current one. There's a presumption of a correctness that plays an important role here throughout this whole appeals process. And that presumption of correctness is going to apply throughout the entire thing. And it's particularly important here at this level with the Board of Equalization because they do give a lot of weight to it. The taxpayer here has a burden of proof that's very similar to the burden of proof on appeal to the Circuit Court. And that's to show two elements. And these elements, again, are something that you always need to be mindful of because it really provides the framework for your appeal. So the first one, it can be one of two things for the first element. It's got to be, you got to show that it's higher, that your assessment is higher than the fair market value, or that there's not uniformity in the application of the assessment. The second element then is that you have to show a violation of USPAP or some other recognized appraisal standard in Virginia. And that's a change actually as of 2011. The General Assembly amended this particular code section. These used to be either or requirements, and they changed it to and instead of or, so that you've got to really show both of these elements. And the Virginia Supreme Court has specifically noted that in several cases. The Board of Equalization has the power to reduce or increase the assessment, so that this is important. You can go in there on appeal saying, hey, we need a reduction here in the assessment, we don't think it's fair, and you can walk out with your assessment actually having been increased. So that's a risk that's, again, present in, at any level of these proceedings. The BOE decisions are deemed presumptively correct for the next 2 years. So in other words, if you go in there for a BOE appeal and come out with a result, that's going to be your assessment for the next 2 years, assuming that you don't go to the next level and get it changed through the circuit court process. Each county sets its own deadline for filing the BOE appeal, and they're also going to say whether a BOE appeal is a prerequisite to filing a circuit court appeal. So that's just something that you've got to look carefully at. The hearings are official proceedings. You as the taxpayer, you're under oath whenever you go in there. You can submit evidence and other documentation. Typically, they like you to do it in advance so that they've had a chance to review everything. And most of the time, somebody from the county assessor's office is going to be in there with you for the BOE hearing. They don't necessarily have to be, but they probably are going to have a representative there. The Board of Equalization actually has power of subpoena, so if they want to, they can call witnesses in to come testify about certain factual issues. And just as a note, the taxpayer can have a representative there, whether it's an attorney or somebody else. So they just have to sign a piece of paper saying that that person is authorized to represent them in the BOE proceeding. Again, the pros cons of this, they're similar to the administrative appeals process. The pros, again, are that it's cheaper and quicker than a circuit court action. The cons are, you may be stuck with this assessment for the next 2 years. As we talked about, they could potentially increase, the BOE could potentially increase your assessment, even if you go in there asking for a reduction. Again, this presumption of correctness is going to apply at the next level in circuit court. And you don't necessarily have the benefit of full discovery and those procedural devices that you would have in a circuit court action. And then, as a practical matter, it doesn't give you the same amount of time to try to negotiate a settlement with the county that you might otherwise have through a circuit court proceeding.
Bill, this is probably a good time to get your thoughts on the BOE process, particularly given your history of being a Board of Equalization member for a period of years.
Well, as the slides, specifically on 13 state, you really have, as a taxpayer, a burden when presenting to the BOE. You got to tell them what's wrong. If the board agrees, then you have to tell them what's right. And if you meet those two objectives, you're likely to get some relief. These are quasi-judicial hearings. While there's going to be a formal filing that the taxpayer has to submit, there will also be rebuttal from the assessment staff, and the BOE will receive those packages in a fairly timely fashion and is expected to have reviewed the materials. What I found, though, in my practical reality of between 2005 and 2013, which embraced the period of the Great Recession, 2008, not everybody read everything. So when you present in front of the board, you should be crisp, sharp on your presentation and hit the high points, direct the members to your submission. because staff is going to be doing the same thing. And then there's a limit. These are not endless hearings. They are normally time specific. I think in Fairfax the time limit was 20 minutes in total for what can be very complex cases. And it's somewhat difficult for the board to fully understand the basis for the complaint and the request for relief unless you really present your facts and your analysis in a very salient fashion. There is some frustration because if the taxpayer believes that they have a number of years at issue, the limitation with the board action is only the current year. And then the presumption that the board decision will carry over is debatable. There are many who believe that no one can bind a political body, such as a board of supervisors or a county charter administration as to the future. So it's hopeful that a board decision would be influencing future assessments, but it's not always, in fact, what occurs. But I do think Board of Equalization hearings, they're much less expensive. They can be handled in a very efficient fashion, and so for a vast majority of taxpayers, they're going to feel like they had their day in court, so to speak, by following the BOE appeal path. But it's not going to necessarily, it's not one size fits all, especially considering the fact that once the BOE decision is rendered, if it affirms, decreases, or increases, that becomes what is then defended if you go on to circuit court. While the original assessments and all of the work that goes into those assessments would still be part of the evidence presented, it's really the BOE's opinion that carries forward at that point and not the original assessment. So depending upon the size of the case, the size of the relief being sought, one strategically may rethink whether they go to the BOE unless they must in order to get to circuit court, and those are where the input of the attorneys are going to be most critical in aiding taxpayers in better understanding the process, the pros and cons, and weighing the evidence they have in light of allowing the BOE to make a good faith effort to get it right versus having a greater period of time in a subsequent circuit court action and, of course, a greater expense to really carry the day in asking for relief.
And just for all the Fairfax County property owners out there, the deadline for a BOE appeals coming up is June 1st.
Yeah, and you can see Fairfax is a good example. The deadline on the administrative appeal was May 1. The deadline on the BOE appeal is June 1, and you don't have there's not a lot of time in between those time periods. Bill made a good point. You really, when you deciding which form of relief you want to pursue, you need to know how much is at issue. And the BOE process, I think, is a great process. Assuming the amount in controversy is not particularly meaningful, you have the abbreviated hearings, just 20 minutes in Fairfax. I've had less time in some surrounding jurisdictions than that. You don't have the opportunity for full discovery, as Brooks mentioned, so there's no deposition of the taxing authority's assessor, which can be really helpful if you've got a meaningful amount in dispute. You don't have a right of cross-examination, which can be a powerful tool at a hearing. On the other hand, Bill's exactly right. All of those things cost attorney time and money, and so this is not a one-size-fits-all process. The fortunate thing about Virginia law is you have these three mechanisms largely available to you, and it's making that decision on which to pick in which circumstance that is, I think, important to your outcomes here. The circuit court appeal is the straight litigation route. Any taxpayer has a right to appeal directly to the circuit court. You need to be aware, though, in some counties, there is a requirement to go to the Board of Equalization as a prerequisite. And so you don't have that obligation, for example, in Fairfax, but in other jurisdictions in Virginia you do. So you want to make sure that you tick that off and don't have your appeal dismissed. The statute permits a 3-year look back plus a challenge to the current year's assessment for a total of 4 total assessments at issue. This is one of the real advantages of being in the circuit court as opposed to the BOE or the administrative appeal, is that you can recapture overpaid taxes, assuming you're successful for a broader period of time. The process runs largely in the same way that a normal civil case would in Virginia, although the big difference here is it's a bench trial. There's no right to a jury in a tax appeal to the circuit court. But the other mechanisms of discovery, like interrogatories and document requests and subpoenas and depositions, are available to you. Although I will say that, at least in my experience, the use of discovery is much more truncated in tax appeal cases to the circuit court than in your typical civil case. You normally will have your appraiser, and you'll have the appraiser from the taxing authority that'll be deposed. There'll be witnesses at trial. Typically, you may have a construction expert or an owner witness that'll be a witness at trial, but usually have many fewer witnesses. 2, 3, 4, or 5 witnesses is about all you'll see in a tax appeal case. The cases are usually pretty quick. Oftentimes, the majority of them, in fact, are not more than a day. More complex cases, say in Fairfax, will be done inside a court week, which is just 4 days. So the cases tend to move faster and are less expensive than your traditional civil dispute, but certainly more expensive than a Board of Equalization appeal. The taxpayer bears the same burden here as you do at the Board of Equalization. You have to prove by a preponderance of the evidence that the assessment is higher than the fair market value or not uniform in application, and also a violation of USPAP. That's that statutory change that Brooks mentioned earlier. And I'm curious, Bill, on your thought on this USPAP requirement. My experience is if you can't meet subpart I, the assessment comes in higher than fair market value, that you've probably done something in the process that would amount to a USPAP violation. So that subpart 2 little I is oftentimes satisfied by proving the first element.
I would agree with that. Yeah, I would agree that specifically if you can't demonstrate that the fair market value was developed in accordance with generally accepted appraisal processes, standards, and so forth, it's very likely that there's an associated nonconformance with the controlling standards that are set forth in USPAP. But keep in mind that the standards don't apply uniformly to all parties. The universe of properties that assessors are bound to follow, that standard is standard 6. The standard that individual appraisers doing single property appraisals are required to follow are standards 1 and 2. So the standards have similarities, but they are not fully aligned with one another. And then if you also have testimony in the form of an appraisal reviewer, those standards in USPAP are standards 3 and 4. So you will find material differences as to how those standards apply to any specific appraisal problem. In the application of a mass appraisal, the standard of uniformity is being really embraced here because that's what the assessor is attempting to do, treat everybody in the most uniform fashion possible. But because no 2 properties are alike, the tension between the standard of uniformity and the standard of value comes to the forefront anytime you have a property with atypical physical characteristics, or you have a market that quite impact like COVID. And so, that's where uniformity can also play a role. It's not the result that is the issue. It's the process by which the assessment was derived. That requires a great deal of data collection on both from the market perspective as well as the assessor's working papers, and then a very close examination as to the methodologies that were applied. If 2 properties are similarly situated, but the assessor used, let's say, a cost approach on one of those properties, and on the other property used an income approach, that would go to a lack of uniformity argument. But if the assessor uses the same methodology but comes up with a different result, well, that just goes to the difference of opinion and wouldn't necessarily impeach that the method was somehow invalid.
Go ahead.
Just on the point about, and I completely agree that oftentimes if you can show that the assessment is higher than fair market value, most of the time you're also going to be able to show a USPAP violation. There's an interesting quick case though from just a few months ago, actually January of this year. It's called Portsmouth 2175 Elmhurst v. City of Portsmouth, and it's 837 SE 2D 504. But in that case, the Supreme Court actually separated these two elements, and it said what had happened in that case was the taxpayer had an industrial property that got assessed at $3.8 million in 2015. In that same year, later on in the year, the taxpayer sold the property for $575,000. And so they subsequently appealed the assessment for the taxes that they had to pay that year, and they said, hey, look, we sold this thing for $575,000. That clearly represents the fair market value, and so we were assessed higher than that. And what the Supreme Court said is that, yes, you've met the first element here because you've made a prima facie case that the fair market value is lower than the assessed value. But then it moved to the second element about the USPAP violation, and it said that they had failed to meet that because at trial, the assessor came in and said, yes, I considered that sale, that $575,000 sale, but I didn't think it was an arm's length transaction. And the taxpayer's attorney didn't cross-examine the assessor on that issue and did not develop any evidence to dispute that. And again, it's always important to keep in mind that the burden is on the taxpayer here, the burden of proof, and the assessor and the county have a presumption of correctness. And so because of that, because there wasn't evidence to dispute the assessor's conclusion that it was not an arm's length transaction, the Supreme Court said that that the taxpayer had failed to meet this USPAP violation second prong of the test. So I think that's a rare instance where you are able to separate it like that, but there's at least one example of it.
You know, that example, go ahead, Bill.
It underscores what John just said. First and foremost, these are bench trials. You may have a judge with a very prolific background in real estate. You may have a judge who only did family law and is not familiar at all with the basics of how real estate valuation is derived. And because it's a bench trial, attorneys may, by agreement, say, let's submit all the reports we have. Or if they're not by agreement, the judge may still say, I'll let it in and try to read it all. But a lot of times, the judges just don't have time or the interest in reading everything, and this is live testimony through experts. So in the Portsmouth case, a close reading of the Virginia Supreme Court's opinion there will demonstrate that notwithstanding all the reports that were submitted prior to the trial, it was the failure of the taxpayer's experts to link the specific allegation of a USPAP noncompliance by the assessor to the actual work product. And so it's not enough to just go on the stand and say the assessor violated standard rules 6-1 and 6-2 and 6-4. You have to specifically link what that standard requires, back it up with what the body of knowledge states in the form of International Association of Assessing Officer publications or publications by the Appraisal Institute, and then link it back to what the specific standard rule required. And that was the shortcoming that I think caused the Supreme Court to affirm in Portsmouth, and that the taxpayer, by demonstrating that the sales price, while not controlling of the subject property, has to be given great weight. That's just the first prong. The second prong is you have to demonstrate what is the correct value. And it was at that leg of the case where I think the taxpayer failed, and their experts just didn't carry the day with regard to linking the assessments, the criticism of those assessments, and how they match up to the controlling provisions of the Uniform Standards of Professional Appraisal Practice. But it underscores how difficult circuit court appeals can be, because it is a bench trial. Judges don't necessarily like them. They're burdensome on their schedule. As John said, if it's a one-day trial, that doesn't give you a lot of time. I would suggest you need a minimum of 2 days and likely 3 days if you can find that within the schedule. But there's a lot of ground to cover, and submitting the reports doesn't necessarily mean that the judge will remember it all, and the live testimony is equally, if not more important, to carry the day.
Yeah, that's a good point. And, sort of linking back to the Board of Equalization appeals, remember that the standard on a BOE appeal is the same as the standard as we have here on the circuit court appeal. It requires both of those elements, the second of which being the violation of USPAP. This case that Bill and Brooks talked about, the Portsmouth case, is only a few months old, came out in January, and I'd suggest that when you have your BOE appeal, one or more astute board members that are listening to it will be aware of that case, and in the limited time that you have, whether it's 15 minutes or 20 minutes that you get in Fairfax, you got to remember it's not enough to just get up and show that your property was not uniformly appraised or assessed, or that it's not the correct fair market value. You also have the burden of establishing in that limited time window that there's a violation of USPAP. And Bill's exactly right. USPAP's not a concept that's intuitive or that's familiar with just everybody. So you need to be able to make that case, and you need to be able to make that case in an environment where you won't have deposed the assessor or their appraiser, and you won't have an opportunity to cross-examine them. So I suggest that burden of meeting the second element in light of what the Supreme Court said in Portsmouth a few months ago may make these BOE cases harder to establish because of that second element. I guess we'll see, and you still want to weigh the relative, cost of going to circuit court versus BOE. But if I'm sitting on a board, I'm going to listen obviously closely to all of it, but I'm going to want to hear the evidence of that second element, violation of USPAP. And I think for many landowners, that's going to be difficult to establish under the procedures available under the BOE process. Settlement by statute, the Commissioner of Revenue for locality has the authority to settle tax appeals. The standard here is interesting because it's different than what the circuit court judge or the BOE has to decide when they issue a ruling. The standard is, quote, substantial doubt that the taxpayer is liable for the taxes paid or owed. So the General Assembly has given the local Commissioner of Revenue's authority to resolve these cases at a lower standard than they'd be litigated at. I know we're cutting into Bill's time. Bill, you want to talk a little bit about the pre-appeal checklist?
Sure. And what you'll find on slide 17 are the relevant Virginia Code sections that I think, as a practicing appraiser and as a former member of a Board of Equalization, attorneys should be very well versed in. Obviously, the requirement to meet all filing dates is incumbent upon the attorney. I know some attorneys get challenged with deadlines from time to time, but these are deadly. And one of those deadlines may have already occurred before the attorney gets involved with the case, and on an income-producing property, that will be the requirement that the taxpayer, upon request by the taxing authority, completed the income expense questionnaire. If it's not, you're barred from producing an income approach subsequent to any BOE or circuit court hearing. And for an income-producing property, that's a pretty difficult burden to overcome. So the second thing, and it might be the most important element that I can bring to the forefront today, is that if you're going to challenge an assessor's work, keep in mind that assessors tend to put a lot of effort into their tax base formulation and the reassessments. They have a lot of information. A lot of it is electronic. There are off-the-shelf programs such as RealVal that a lot of local municipalities use, and therefore they have a wealth of information. And you as the taxpayer are entitled to see all of that data. And it's in that data that you are going to find either a lack of uniformity or a mistake of fact or noncompliance with a generally accepted appraisal standard. So if you don't review the working papers, you're really going into this blind. If you do review the working papers, that is going to yield whether you're on solid ground or whether you're kind of have an uphill struggle here. And in light of the examination of the working papers, the code provisions recognize that the professional organizations, such as IAAO, the Appraisal Institute, it's their textbooks, it's their guide notes and so forth, that compliance, in other words, USPAP will tell you the minimum, but how do you interpret what a USPAP standard says? You interpret it through whether that standard was correctly employed through the educational materials of professional appraisal organizations. So that's the third leg, that once you get the working papers, you have to examine them in accordance with generally accepted appraisal practice. And then if you are convinced of the correctness of your position, you need to then assemble your facts, your market data, and present it in the same criteria called for in USPAP. For instance, USPAP 1 is the development of an appraisal, single property appraisal. USPAP Standard 2 is how that's communicated, either orally or in writing. So, even though the taxpayer won't necessarily be licensed, it's likely you will have a licensed expert at this time, and that party will need to fully comply with USPAP as well. And as I mentioned previously, if you have a review appraiser involved, there'll be a different set of standards, standards 3 and 4, and that review also has to be done in strict conformance. And then it has to be presented at trial in a succinct, crisp fashion so that the judge understands the critical elements you're trying to bring to the forefront. Moving on to the next slide on the USPAP issues, as I said, it's a biannual publication. It is recognized now in the code. It's required for licensed appraisers, but some assessors are exempt from most of the provisions. And then you have the 5 USPAP standards that all attorneys should familiarize themselves with, being first and foremost Standard 6, which covers ad valorem property taxation. If you're hiring an expert, that expert should be very proficient in the application of Standards 1 and 2. And if you're hiring a review appraiser, he or she should be very proficient in the application of Standards 3 and 4. And if you're going to basically allege nonconformance, you have to fully document it, and you have to link it to the work product, and as well as what the standard requires. And in an abundance of caution, I would further link it to what the educational materials of IAAO and the Institute also require. The valuation process is set forth in all of those publications. It's a 6-step process. It's fairly orderly. It's the equivalent of the scientific method as applied to the appraisal industry, and it's really something that is logical in its format, and it will yield a good result. Looking at the assessment appeal red flags here to close out my comments, anytime you see a substantial increase, that by itself isn't necessarily meaningful, because it could be that the assessor hadn't revisited that particular property card for a number of years and just trended it forward, or it could be that there has been market changes in the local submarket at issue. And the basis of an appeal, a valid appeal, isn't the fact that your assessments went up. The basis is, why did they go up? And in that regard, was there a disregard of market data? A lot of times an assessor, in culling the data that they receive in the form of deeds across their desk, will say, this sale doesn't make much sense. They'll code it as a non-market transaction, put it aside. And therefore, it won't necessarily go into the data that drives some of the mass appraisal applications that are done electronically using the software that many taxing agencies used. But you may find that further examination of those non-market coded transactions are in fact indicative of a change in the market. In a decreasing market, the initial transactions may not align with the prior thinking and trends of the assessors and what they've identified, but when they become the preponderance of the market data, then it's a whole different issue. Anytime you have an assessment developed by a sole approach, and most often you will find that the assessors will rely on the cost approach solely. As long as they considered and had valid reasons for why they did not develop the other traditional appraisal methods, being the income and sales comparison approaches, they may be able to sustain their evaluation based solely on the cost approach, especially if it's a special use property, such as a stadium that really doesn't have another application or is a limited market property. If there's an assessment based on an income approach, but you find that there's really no support for the inputs made by the assessor with regard to rent, vacancy, operating expenses, and capitalization rates, that's another red flag. And then lastly, the sales comparison approach. A lot of times assessors will base their sales comparison approach on a qualitative type of approach where they'll cite 3 or more transactions and pick a number in between the lowest and the highest and say qualitatively the subject property fits that mode. But that still begs for, are there differences between the 3 comparable sales in that example and the subject property, and would a qualitative or quantitative adjustment alter that bracket or range of value? So, these are generally accepted appraisal processes that don't conform to the minimum requirements of USPAP, and those are basically 3 illustrations of why there would be a red flag associated with that. So, each property is unique. They have to be considered on their own merits, but it's the devil's in the detail here.
Okay, we've got some questions. We'll try and get through these questions. I know we're perhaps over time, but I think I can go through them pretty quick. There's a great question about the time constraints. The question is, although there are time constraints with the BOE, should this be balanced with the level of experience the board members have that the circuit court judge may not have? That's a great point, a great question, a great point to make. The answer is yes. The theory behind the Board of Equalization is you're going to have at least an appraiser and a real estate professional. You'll have individuals on the board who have some form of training in this subject matter specifically. And as Bill mentioned, your circuit court judge may have no experience in real estate at all, may have come from a different background. So the theory is you will have informed members on this board who should understand these concepts. And when you consider the administrative appeal, that's certainly a plus, a pro in terms of that process.
Yeah, and there's actually a case that helps demonstrate this. It's from last year. It's called McKee Foods v. Augusta County. It's 297 VA 482. But essentially there, and keep in mind, there's also a difference between circuit court judges in, for instance, a Fairfax County, who probably have seen at least some of these tax appeal cases, and circuit court judges in more rural counties like here, Augusta County, who probably haven't seen a lot of them. And in this particular case, the circuit court judge had the taxpayer and the county, who each submitted a ton of evidence, multiple appraisals, had multiple experts on each side. And at the end of the trial, basically the trial court judge just threw up his hands and said, I don't know what's going on here, but because the county enjoys a presumption of correctness, I'm just going to go with them. And the Virginia Supreme Court said, no, you really can't do that. That's not a good way to handle these circuit courts. So it sent it back and said, you really need to dig into this a little bit more. So, it's definitely a consideration, the experience of the judge.
Next question asks whether it's permissible to try the administrative appeal first and then go straight to the circuit court so long as a BOE process is not a prerequisite. The answer is yes, and oftentimes that may make the most economic sense for a landowner to start with the administrative process, which is fairly friendly, it's informal, it's inexpensive. You can oftentimes get what amounts to free discovery from the taxing authority, and then so long as your jurisdiction doesn't require that you go to the BOE, then you can go to the circuit court and get the benefits there. There's a question specific to you, Bill. The question is, Bill, in your experience, how do local jurisdictions take into account properties running businesses like franchise restaurants that are often sold on a sale leaseback basis? I don't know if that's too
well, that's
specific.
That's a very controversial issue in the appraisal field right now because of the discussion as to the differences between fee simple and lease fee, as it applies to as well the credit ranking of the particular tenant. So I will say that the assessors are looking first and foremost at the real estate value. With regard to going concerns that require an allocation of the component parts that make up the going concern to get to the real estate value, that's when you can have major differences of opinion. There's not even agreement on the accepted approaches by which such allocation will occur. But I do think, the assessors will make every effort, and they will also attempt to make sure that they're uniform. Just because you're a franchise restaurant, they have to treat all restaurants similarly. So you will find that the franchisee or the brand, so to speak, may have an impact, but hopefully the assessors have dealt with that impact by employing a uniform method.
So another question, Bill, that if you can tackle, the issue is, does a January 1 valuation date effectively remove the COVID-19 impacts from the discussion in any appeal? And is that something that would have to be taken up after next year's assessment?
Well, I think the practical reality is the executive orders issued by the area governors basically came out in the beginning of March. I think Maryland was March 5th. Governor Northam was March 12th. So, the date of finality being January 1, you don't know what you don't know, and you're standing in the shoes of the assessor on that date. Obviously, while COVID may have been present, it wasn't necessarily being observable in real estate transactional data. However, in Virginia, you've got the Dennison precedent, and Dennison basically said appraisers use pre-valuation data all the time, and they adjust it from that historical date to the effective date of value. And what the Supreme Court said in Dennison was, well, you can do the same thing in reverse. You can use post-valuation data and adjust it back to the retrospective effective date of value. But that's kind of circular logic here, because if COVID-19 has a negative impact going forward, which it's obviously going to have on lots of real estate, but it may have a positive impact, if you can believe that, on limited real estate such as data centers, given now the widespread use of electronic bases to work from home-based operations. But if you adjust the data back post January 1st, 2019, you have to comply with Dennison. Therefore, you're basically taking the COVID influence out of the equation. So it's kind of circular logic question.
We have two more questions. One, and I don't know the answers. We may have to get back to you with the response, but I'll read it, and Bill may have some thoughts. Question is, I am an MAI based in Richmond with experience in tax appeals in Ohio. In Ohio, individual school boards have the ability to file an appeal to raise one's assessed value based on a recent sale of the property. Do governing agencies, I assume in Virginia, have similar appeal authority? And I don't know the answer to that question. We can look into it. Bill, do you have any thoughts?
Yeah, I'm going to say I don't have a bar card, but my lay opinion is that you cannot, the date of finality, January 1st, sets the assessment. And an assessing authority can appeal to the circuit court to raise an assessment, but it would still be as of the date of finality. Any post-valuation data would go to the following year's assessment. So I just don't think, as a practical reality, you will see any municipal board or agency, asking for such, although we are heading into some unprecedented conditions where municipal budgets are going to be exceedingly tight. But I'm only aware of a handful of situations in my almost 10 years on the board where the assessing authority asked to have an assessment increased as a result of an appeal. I will note that on the last page of the slides, page 20, are 3 important resources that may aid all parties. These are guide notes produced by the Appraisal Institute, and they really help with the breakdown of how the influence of a disaster or a major influence such as COVID affects real estate values, what you have to do when such a declining market exists, how you get the best data, and in general, what type of market trends you need to analyze, what type of data you need to seek. So I would recommend that all attendees, avail themselves to downloading those guide notes, take a look at them. They will help you moving forward, especially if COVID-19 becomes as influential on property values going forward as many may think.
Great. I think I have one more question. If I've missed any, I apologize. We'll look at the questions and respond to any we may have missed, but I think this is the last question. Is it fair to say that real estate valuations will go down due to the current market conditions, but county tax jurisdictions' real estate taxes will go up next tax year? And I'll let Bill answer that. I'll quickly say, I don't know what will happen with real estate valuations. It looks like things are trending down, but we track the market, and at least in this area, prices are seeming to stay pretty firm. I can tell you the jurisdictions that we've got here in Northern Virginia, even with the market down, our local governing bodies are anticipating more total revenue based on an increased real estate tax base. You just have more taxable properties, even if market conditions may be deteriorating. Bill, do you have any thoughts on this question?
Well, the taxes are a function of assessed value times a tax rate. So the ultimate answer is it's a political question. What will the local municipalities' powers to be decide as to how they're going to fix the tax rates? As you mentioned in the beginning of this webinar, with the revenue streams going down, the majority of revenue streams trending downward, the only way municipalities are going to have to make up the hole in their budgets is to increase taxes. So even if assessments stay the same or go down, the powers to be, by raising the tax rate over and above the equalized rate, can cause taxes to go up. And so I think it's more likely than not that you are going to see some very, very difficult political decisions going forward because of the necessity for municipalities. Unlike the federal government, we don't have printing presses with ink. We need to balance budgets, and therefore the ultimate balancing act will be setting the tax rate.
Exactly right. There are actually a couple jurisdictions. I'll sort of end on this note. Not in Virginia, but there are a couple of jurisdictions that have dramatically increased their tax assessment, and the reason for that they've given is COVID-related budget shortfalls. The city of Nashville was one that made the news. They've increased their real estate tax rate by 37% to address the other budget shortfalls. I don't think we'll see anything like that here, but Bill's 100% correct that when these other revenue streams dry up, and they are, that real estate is viewed as a safe way to make up that difference. Well, I think that's all the questions. I know we've run over time. I want to thank everybody for joining us in this, and particularly thank Bill for lending his expertise to us. We'll try and follow up by email if there's anything that we did miss, but otherwise appreciate everybody's attendance.
I think we'll call it a wrap then. Thank you all.
Thanks, guys.